Well, this is a very important question, and this is a question which whose answers should be known to the practicing lawyers, and especially the law students who are going to come up and practice criminal law litigation. So, in a lot of cases, even after the judgment of Lalita Kumari pronounced by the Honorable Supreme Court, the police station still does not lodge the FIR after receiving the complaint from the complainant. The police probably feels that there is no cognizable offence which is being made out. The allegations which are being made in the complaint are, motivated allegations and biased allegations, and hence does not file the FIR. It does not lodge the FIR on that particular complaint. Now, in this case, the aggrieved complainant, who is aggrieved by the fact that the FIR is not being launched by the police station, can move to the superintendent of police, which is usually an IPS officer who's very high in ranks, and that particular complainant can write an application to the SP stating that he or she has a very strong case in which clearly a cognizable offence has been committed against him or her, and hence the FIR should be lodged. And in case the SP also does not take any action like the police, like the local police station, then the complainant can move to the appropriate magistrate who governs that particular police station through an application under section 156.3, where the entire application under section 156.3 details the offence ingredients and details as to how exactly the offence has actually been committed. And in spite of the fact that the complainant visited the police station and the SP, no FIR was lodged. And hence, in such cases, when the magistrate hears the complainant through his or her counsel, then the magistrate applies his or her mind, and if he or she feels that a cognizable offence has been made out, then the magistrate, without any delay, directs the local police station to lodge the FIR and commence the investigation, which essentially means that you have a remedy in judiciary against an illegal action of an executive, because police is a part of the executive, magistrate is a part of the judiciary, and hence this is another example of how checks and balances have been made in our procedure, keeping in mind the entire concept of separation of powers, where even if the police station does not entertain a genuine complaint, you can always approach a part of the judiciary and get the complaint lodged.